This lecture is on courts and criminal trial. Current event assignment. Check your discussion forum or just discussion board for the assignment associated with this lecture that's due this week. First thing we'll talk about judges. Three methods of selection. They can be appointed by the governor, or there's a merit selection where a committee submits 3 names to the governor, and or there could be a nonpartisan election, meaning they don't run on any political party, or they could run representing a political party, or there's a hybrid. They're appointed and then run for office. The judge's role in the accusatory process and trial. In the pre-arrest phase, they review requests for and issue or deny search or arrest warrants. In the initial appearance, they advise the accused of their constitutional rights, they determine bail and pretrial release, and they also discuss if the case should be dismissed. They decide if the case is going to be dismissed. Preliminary hearing, they evaluate the prosecution defense claims regarding probable cause and decide whether there is evidence to hold the accused for arraignment. They rule on bail reduction requests, and they continue to advise the accused as to the rights that they might have. In arraignment, they evaluate the indictment or information and advise the defendant as to the pleading. They ensure the defendant understands the impact of a guilty plea or nolo contendere plea with regard to waiver of some rights. Pretrial, they rule on pretrial motions and answer requests for continuance. In the trial, they oversee jury selection. They rule on evidence and other aspects of the adversarial procedure. They instruct the jury as to legal rules affecting the case and charge the jury and receive the report of the deliberations. If a non-jury trial, they determine the guilt or innocence. In a non-jury trial, that's called a bench trial. And here the judge becomes the trier of fact and the trier of law. Only 5% of all cases are heard by a jury trial. The rest are pled out or they're bench trials. The Sixth Amendment is which sets up the structure of the courts, and it basically says that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district within the crime shall have been committed, wherein the crimes have been committed, to be informed of the nature and cause of the accusation, and to be confronted with the witnesses against them, to have compulsory process for obtaining witnesses in their favor, to have assistance of counsel for the defense. Interesting situation with regard to criminal trials is factual guilt. Having factually committed a crime does not necessarily mean that one legally committed it. In other words, you might have killed someone, but it could be in self-defense, or it could have been a mistake. You could have been in fear of your life, or it could have been an accident. You might have stolen some property, but the officers violated your rights under the Fourth Amendment, and therefore the evidence is inadmissible, and therefore, although you're factually guilty, you're not legally guilty. Rights to confront witnesses. Basically, the Sixth Amendment allows you to have control over hearsay evidence and the veracity or the truth of witnesses, and you could challenge them. You can also subpoena people into court to make them testify on your behalf. It helps the accused in preparation of the defense to know who will be present, because you should be getting a list. And it doesn't necessarily mean face-to-face confrontation, but it allows you to know who's going to be there, and if someone knows that you're going to have to face off with them and they're lying, the chances are they will not show up to court. Right to a jury trial. This right is not guaranteed for all serious crime. Is guaranteed for all serious crime, but not all crime, like traffic violations. You don't get a jury trial if it's just going to be a fine. The Constitution doesn't require 12 persons on the jury. Smaller juries can be permitted. The 6th and 14th Amendment do not mandate a unanimous verdict in all cases, so each state can, through their own constitution, change whatever rules they want. Right of counsel at criminal trials. We talked about this in the last lecture, but this basically gives you a timeline. Bill of Rights in 1791, the 14th Amendment in 1868, Powell versus Alabama in 1932, Gideon versus Wainwright in 63, Galt decision in 67, and the Galt case was basically a juvenile who requested an attorney, and the policy had been that the probation officer would work to represent both the prosecution and the defense. And he said, no, 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 I want an attorney, and as a result, it changed how juveniles were dealt with. Argersinger versus Hamlin was in 72 that said that anytime you have a possibility of going to jail, even for a day, you get an attorney. You have the right to an attorney. Self-representation. Saying is a person who represents himself as a fool for a client. Requires a competent, knowing, intelligent, and voluntary waiver of counsel, and it requires the defendant to understand the charges. But it is possible to represent yourself. Another big issue coming up is a fair trial versus free press. You know, having the press in there. If you can remember the O.J. Simpson trial, anybody that watched that saw that Judge Ito had to be really in control of the press because the cameras in the courtroom would view notes going between O.J. and his attorney, which later could be looked at the prosecution. They could find out what their strategies were, and he would stop the trial, and shut down the cameras. At times he had a switch, he could shut all the cameras off. And he did it a couple times because he felt they were violating the rights of the defendant. Jury selection. Names are taken from various lists, including voter's reg, hunter's license, driver's license. A jury pool is developed, and a computer pulls those names. It used to be like bingo, but now they have a computer that does all this. Looking at jury size for felony and misdemeanor trials, you can see that there are a variety of different sizes, 12, 8, 6, 7. I think Florida tried at one point to get down to 5, and the court said, you know, we're going to leave it at 6. 5 is not much different than 6, but we're going to stand on 6 as being the minimum for criminal trials. Contra Costa County, what they do is they mail you a digital badge with your name on it, and you wear it to the courtroom on the first day of your jury duty. A bar reader is then flashed at you, and they know exactly who you are and where you go. Once you've checked in using the barcode reader, the computer provides the judge with a list, and they're able to determine who's going to serve on the jury. Voir dire. Voir dire is a word you should know. It means the examination process of the jury. This is where the prospective jurors are questioned by prosecution and defense to screen out persons that might be biased or incapable of rendering a fair verdict. You have what's called challenge for cause. This is a removal of a prospective juror due to bias or some other factor contributing to the inability to make fair decisions. There's no limits on challenges for cause. Preemptory challenges, on the other hand, there are some limits to it. Some states allow 8, some allow 10. It's removal of a prospective juror by the prosecution without providing specific reasons, the way the person stared at the defendant, the way they dress, or just the way they answered questions. You don't feel that they're going to be fair, but there's no legal basis for it. Currently in California, the judge conducts a voir dire and makes it go along a lot faster. After the Victims' Bill of Rights passed in the early 80s, it gave the power to the judge to determine what questions would be asked. Now, witness examination, you have what's called direct examination. This is the first examination of a witness conducted by the side that on whose behalf the witness was called, and they would ask a certain number of questions regarding a certain subject. The other side then gets to cross-examine, and this examination of the witness by the party opposed to the one who called the witness. They can only ask questions in regard to the same topics that were originally asked. These are the steps in a jury trial. So after the voir dire, prosecution opening statement to the jury, then the defense opening statement to the jury, then the prosecutor's presentation of evidence and direct examination, then the defense attorney's cross-examination, then the defense attorney's presentation of evidence and direct examination. And they could stop right there, because what could happen is the defense, before they even present their case, could say, Your Honor, we want to move to a directed verdict of not guilty based on the fact that there is not enough evidence to show beyond a reasonable doubt my client committed the crime. And the judge could make that decision at that point. But let's say that that doesn't happen. Then the defense presents their evidence. Then the prosecution gets to cross-examine. Then they have closing arguments by the defense, closing arguments by the prosecution, then the judge's instructions to the jury on the rule of law, evidence, and the standards of proof associated with that crime. Then the jury deliberates and votes, and then there's a pronouncement of a verdict, and after that, after the person's found, if they're found guilty, then the judge will sentence them. Now, before the jury is set off on the task of deciding guilt or innocence, it's the judge's responsibility to provide them with information about the law regarding the elements of the crime of the instant case, the evidence required for proof, and the burden of proof required. Improper instructions are often the basis for appeal in many cases. Criteria of admissibility of evidence. It has to be relevant, material, non-prejudicial, reliable, and legally obtained. Criminal evidence can include testimonial evidence from witnesses, real or physical evidence, circumstantial or indirect evidence, and the primary test for admissibility of evidence in either a criminal or civil prosecution or proceeding is its relevance. Does the material have relevant evidentiary value in determining the issues in the case? This slide shows evidentiary standards. So let's go through these. Absolute certainty. Definition, no possibility of error. You're absolutely sure the person committed the crime. Where is it used? It's not used in the United States in civil or criminal matters. The next level or standard is beyond a reasonable doubt, more certainty. And the definition is a conclusive and complete proof while leaving any reasonable doubt as to the innocence of the guilt of the defendant, allowing the defendant the benefit of any possibility of innocence, and this is used in criminal trial. Next standard is clear and convincing evidence. This is prevailing and persuasive to the trier of fact, and it's used in civil commitments and insanity defenses, and many times this is the level that's used in investigating police misconduct. Preponderance of evidence is next, and this is a greater weight of evidence in terms of credibility, more convincing than the opposing point of view. This is used in civil trial, where you're trying to prove that the other person is liable for the injury that occurred. Next level or standard is probable cause, and this is the standard we use for making arrests and search warrants. Sufficient evidence is adequate evidence to reverse a trial court. This is used in appellate review. Reasonable suspicion is what we use to detain people. It's usually used in police investigations. And less than probable cause is mere suspicion, and we might use it for investigations, but we don't stop or detain people based on that standard. Proof beyond a reasonable doubt. What does it mean? It's a doubt of 7.5 on a scale of 10. It's a doubt based on reason and common sense. It's substantial doubt. It's persuasion to a moral certainty. And it's a doubt that would cause a prudent person to hesitate before acting in a matter of importance to themselves. I once asked a traffic judge, I said, how do you know? How do you find these people guilty? And he says, you know, I listen to both sides, and if I have any doubt at all, I find them innocent. Now, after the person's been found guilty, they're going to be sentenced, and what the judge does is they order a pre-sentence investigation done and prepared by a probation officer. They do a background and characteristics on the suspect. There's also a chance for appeal where after conviction the whole case can be sent to an appellate court to be reviewed to see if there's any errors. Habeas corpus means it's a writ or a judicial order requesting that a person holding another person produce the prisoner and give reasons to justify continued confinement. Let's say in a case where it's found that there's substantial evidence. One of them now that's happening is with analysis of DNA in cases where semen or blood samples were found in convicted people in certain sex offenses, and now they're running the DNA and finding it's not the person that was convicted. You could file a writ of habeas corpus and get them pulled out of jail and brought in for a new trial or for a hearing from a judge. Sentencing. First of all, the goals of punishment are retribution for the family and victim, because if they don't feel they're getting that the person's getting a deserved punishment, they may go out and commit acts based on vigilante justice, and so we need to prevent that and have some sort of faith in the law. The next goal of justice is deterrence. If people see people getting prosecuted and punished, they will not repeat the same offense. Next is incapacitation. You have some people that are criminal predators that no matter what you do, they're going to continue to commit crimes and hurt people. And what we do is we isolate them from society in jail. The last goal of punishment is rehabilitation, where you may be able to provide some skill that they learn in jail or through counseling or medical treatment that helps a person not to repeat committing offenses. Application of criminal sanctions. They include incarceration. Indeterminate sentences are those sentences that have a lower and a top end, and the person who's been convicted can serve anywhere in between those two different numbers. Determinate sentences is what we use mostly in California, except for a couple of different offenses. It may say something like 2, 3, or 4 years, and in most cases the judge is required to take the middle sentence, but they have the opportunity to write paper to show that they should get a more strict sentence or a more lenient sentence. Mandatory sentences are a minimum sentence for selected crimes. By law, the judges don't have a choice. They have to sentence these people to this mandatory sentence. Intermediate sanctions are more restrictive than probation but less expensive than incarceration, and these could include things like electronic monitoring. Probation is a sentence served in the community under supervision. May have other sorts of requirements like drug testing and stay away clauses and curfews, and have to go to certain programs, counseling, school. Shock probation is where the convict serves a short amount of time and then is released on probation, so they get a taste of what they're going to get if they don't follow the rules. This has been a highly successful program using shock probation. The death penalty, of course, is allowed in many states. California uses the gas chamber and currently is using the current standard is lethal injection more so than the gas chamber. The appeals process. I'm going to assign you to read in the book, and you can look at most of the appeals process, but different sorts of writs that you'll be looking at is mandamus, which is order from a lower court to comply and perform a duty by law. Certiorari, which is a requirement that all the records and transcripts be sent up to the appellate court to be reviewed for error, usually. And here are your key terms for this lecture. I'm going to allow you a second to read this. I would pause, if I were you, I would pause the movie at this point so that you can write these down. And that's the end of this lecture.